Hello, everyone, and welcome to CLI's Digital Literacy eDiscovery mini-series. I'm absolutely delighted to be presenting this today in collaboration with Enhanced Litigation Management Solutions, or you're going to hear us call them ELMS throughout the course of this, I'm sure. Huge thanks to Kate Clark, the CEO of ELMS. Hi, Kate. Good to see you.
Hi, Terry.
Thank you so much for collaborating on this with us. Really, really appreciate it. This is the first of a 5-episode series. This one, as you will know, is going to focus on the eDiscovery evolution, and in many respects will be setting the scene for the other 4 episodes that will come. This will be running from February through to June, so you've got an opportunity to jump in almost every month to one of these sessions, and it's really going to pull the eDiscovery, I'm going to call it a process, apart, and really do a deep dive into critical aspects of that for you to understand it, or perhaps to expand your knowledge, or to use it as a training tool for the folks, your colleagues and others that you're working with in this area. Kate is going to be joined throughout the series with some wonderful co-presenters, as we can see here today. And if I may introduce them to you. Nick Androtridis, I hope I've pronounced your name correctly there, Nick, who's a QC. Nick, hi, thank you very much for joining us today.
Good afternoon, everyone.
Nat Burgess, who's a Senior Associate at Maddox. Hi, Nat. Good to see you. And Kiri Parr, who's a former General Counsel at Arup. Hi, Kiri. Great to see you as well. So as you can see, all of these folks are from slightly different backgrounds, which we think is going to add to the depth and the richness of the discussion on these points today, because they will be coming at it from a slightly different point of view. Okay, Kate, you ready to kick us off with this one? We're going to start at the very beginning with a definition of eDiscovery. What is it, and when did it become a cool thing in Australia?
I like that you say it's a cool thing. I think it is, but I'm not sure everyone would agree. So Terry, eDiscovery is all really about the electronic management of documents in litigation. And just to explain further what an eDiscovery consultant does, so that you have the perspective on that, in simple terms, we use our knowledge of the litigation process. We combine that with our technical consultancy skills, and we use some really nerdy, cool technology, really cool, well, for us anyway. And we're going to find some information from your client's premises. We're going to collect it, and we're going to organise it into a user-friendly format for the legal teams to review.
So what are the sort of things that you're looking at? Just roughly throw out. There's obviously emails, documents, what other sorts of things are we throwing into the mix?
That is entirely dependent on the type of matter it is. So what our process would normally be, we would talk to the law firm, we would understand what the claim is about, we would then go into their client's office and identify the document sources that might contain relevant information. And then we would go back and forth with the IT team and the lawyers to discuss which ones we're going to collect, and then we organise the collection and we get it into the database as quick as we can for their review. So there's lots of different types of information, lots of different sources. You can go right from, we've collected documents from shipping containers out at the dock, right through to really in-depth database, construction type databases that you collect information from. So you just need to understand what you're looking at in your claim to inform you as to what you need to look at, the sources of documents that you need to collect along the way.
And I guess it's worth also mentioning the metadata, the data about the data, so to speak. I mean, that's also part of what's in this kind of big cauldron of things as well, isn't it?
Yeah, that's certainly the gold. We call that the gold, and our aim is to not try and alter that in any way. So we work very closely with the lawyers and their client to ensure that when they are collecting documents, if we're not doing it for them, that they don't alter that metadata. And you know, that's typically where we like to get involved right at the start, because if you bust that metadata or bust your document dates, it's going to cost you a lot of money to fix it down the other end. So we try and avoid the spoliation of metadata on all fronts throughout the matter. And it's really important to keep the integrity of the documents solid throughout the process.
Fantastic. So it's covering a lot of stuff. And Nat, I wanted to kind of ask this of you as well. I guess what we've been talking about mostly, Kate, to start with is civil matters, your civil litigation. But Nat, as I'm listening to Kate, I'm thinking that there's a bunch of other places where you might want to be thinking about eDiscovery as well for organisations as well, like, compliance investigations or freedom of information requests. Does it stretch that broadly?
Look, I think it does. I mean, I'm a legal practitioner in a commercial law firm, so usually discovery is my first focus, document disclosure. But in the past, we've used this kind of process for gathering documents, not only for things like freedom of information responses, but also responding to subpoenas is another example where you have potentially a lot of material that you need to sift quickly and identify what's relevant to the categories that you're being asked for. So that's, I guess, litigation adjacent. Nonetheless relevant to civil litigation, but perhaps not a traditional use that people might be familiar with.
Thanks for that. Nick, I wanted to ask you this question, and particularly as a barrister, all of this stuff doesn't happen in a vacuum, right? eDiscovery, it not only extends to civil matters, but criminal matters, but there's a bunch of legislation and rules around all of this as well, right?
Yes. I mean, the modern theory of running litigation, whether it's in the traditional court space or in arbitration space, is there'd be a level of cooperation between the parties on things that don't matter, in the sense of, the document management and the logistics. There's an expectation that everyone will behave in a logical, sensible way, so that the ultimate clients are only paying for a fight about the stuff that actually matters, the legal bits. Now, there's a lot of hard work that goes into that, and obviously a cost associated with it, but ultimately it's a much more efficient way of dealing with things. And depending on the space you're in, yes, there are frameworks about what you can and can't use and how you use it, but the expectation is that we will behave in a sensible way. And if there's nothing controversial about the contents of a document, whether it's paper or electronic, we don't fight about the existence of the document as opposed to fighting what it means.
Yeah, absolutely. A great segue, by the way, to the next question that I wanted to leave with you, if I may, Nat. If we look at eDiscovery from kind of the 40,000 metre level, what are the big ticket items, if you like, that recommend it?
Look, I think the process of discovery is really a critical one in the litigation process, and what I look for as a legal practitioner is a process that's going to give me confidence. This is a part of the litigation journey that is really significant for a variety of reasons. You're looking, I'm a construction disputes practitioner. The litigation that I have conduct of is very large. It involves often hundreds of millions, if not billions of dollars. There are a variety of documents and information from a variety of sources. We're having to resource it from IT departments, finance departments, project teams. So what you're looking for is a process that's going to give you value for money, because it is also a significant component of the potentially millions of dollars that your clients will spend in a litigation. You are looking for confidence that you are satisfying your own obligations as a practitioner, as well as the obligations of your client to give full disclosure in accordance with what's been agreed or what's required by the rules, and also that you're identifying the relevant documents that are going to put your best case for your client. So for me, it's really about it's about giving you confidence that you're providing the best service you can, as well as meeting all of those obligations. You also want a process that's going to give you confidence about the likely cost. As I said, it's a big component of the overall cost. So you want some notification in advance about what those costs are going to be, and also about managing the risks of document production generally. You want a system that's going to be secure, that's going to have the accessibility that you require, and also has the necessary storage capacity demands that a very large litigation requires. So for me, it's really about having the confidence that the system is going to give me and give my client the best possible position for their case.
Yeah, absolutely. And Kate, I want to just do a check-in with you there, because I know that we've chatted about, just how many documents we can be talking about in one of these. Share with us the largest number of documents that you folks have processed.
Yeah, so we had one case a few years back, and it got up to about 10.5 million documents before it settled. We were very much looking forward to going to an e-trial, but that didn't happen. But yeah, but I suppose the message these days is because of the software and how it is stored now, that is stored in a SaaS environment, so you don't actually have to carry the infrastructure yourself. It is actually a piece of software now that you can use on any size matter. And we would suggest that lawyers start looking at it over 1,000, anything over 1,000 emails, because if you have 1,000 emails and you have attachments to those emails, you can pretty quickly get up to 4,000 or 5,000 documents that need to be reviewed, and it is simply just more efficient to review it in a litigation database. So it's not just for the big cases anymore. Obviously, it is super helpful on a big case, but you can use it on any size case.
Yeah, and important to underscore that, and that as I think we're just about to chat with Kiri about, really, that it's something that can almost, I guess, be a catalyst for best practices around a whole bunch of different things as well within your organisation or firm. So Kiri, if we're kind of looking or getting ready for the eDiscovery process, and I'm not talking here about the process itself, because obviously we'll do a deep dive into that in episode 2, but there's a whole bunch of big items, I guess, that we need to consider. So I'm going to pull it out in pieces for you and kind of do them a little bit at a time. From all that the folks have been saying so far, there's a lot of skills in play here. There's obviously lawyers, there's IT folks, there's some sort of information governance or record management system going on, and you're managing internal and you're managing external. So how does all of that come together? Who do you need on your team?
Well, I was going to start with the proposition that historically, I think this discovery process was highly siloed. And that has cost consequences and efficiency consequences about how you go about this job and how you bring these skill sets together. So it's no longer an approach where, the record keeping is so straightforward and simple that you only need the lawyer's skill set so that the lawyers can comprehend it all. We're needing to bring these skill sets together. And I think when this technology was emerging, the prime conversation happened between two lawyers. And as it's become more complex, as the size of the databases have become more complex, as owner organisations become more complex and handle their data in different ways, the IT infrastructure of an organisation differs from company to company, and it's very different from how lawyers organise themselves. So for me, the main thing that really you had to start doing was working out how to bring those skills to the table to help solve your problems. So for me, what became really critical to actually get the efficiencies and the good solutions, and I love Natalie's comment about, you need a reliable system that works, that's meeting their problem. I needed to bring all those skill sets together. So for me, it was, as you're building that strategy, it's like I didn't just have the conversation with me and the partner of the law firm, and I didn't ever want to make it somebody else's problem, because it was my company's problem. How do you extract 10 million records from a company without really disrupting the company and their system? So if you are able to put the skill sets that you need around the table, what's the lawyer's problems? What's the organization's problems? What are the IT skill sets? And they're I love the meetings where I had the CFO for my own company in the room together with, my eDiscovery specialist, because then you go, oh, that's what you're wanting to achieve. This is the way to do it. And you just solve problems at the outset.
Is there something in that about finding, I don't know, a common language almost to be able to use that everybody can agree on and work with, and it makes collaboration that much more effective?
Yeah, and that issue of language is actually really, really interesting, because I think that's if you're not a technical specialist, technical people will say things in a particular way and assume it means means things. I think the technical word for it is we have language of domains. And the lawyer's understanding of the world and how it works is actually quite different from the IT people. And they can say something in one word that actually we haven't even grasped the complexity of it. And lawyers do the same thing to the IT people. And then you've got somebody in the room who may not understand either languages, and then they're completely lost. And you can, if you don't spend the time unpacking where everyone is and their mutual understanding of that problem and what they're going to do, the mistakes get so easily made. And I love this spoilation of metadata. You know, if a lawyer just says, or the in-house counsel just says to somebody in the admin team, oh, can you just go and copy those emails off that person's account that have this in the subject line? Suddenly somebody goes off and does a task, and they do it in what they think is the right way, but they've misunderstood. They're solving a different problem. And it all starts with that miscommunication around language and what people do and the tools that we're using.
And Terry, can I just add something
Sure.
to that? I think that's probably where eDiscovery consultants are very helpful, because they can generally speak IT and speak legal. So we can sit in the middle and translate between those two different types of people. And I think that's a really, we spend most of our day dealing with the client's IT team and then translating that into legal speak and then finding out what the lawyers want and then translate it into IT. We can get the outcome that we need.
And can I just add?
Please, yeah.
That's actually a critical connection, because people like Kate make the job of someone like me much, much easier. And having that confidence that I can speak the legal stuff to someone like Kate, and understanding that Kate gets it, or someone else like Kate is wonderful, and it's critical, I think.
Yeah. And Nat, I should ask you this question as well while we're on it. Same sort of thoughts in terms of the law firm perspective on that?
Yeah, that's right. I think that interaction between technology and the requirements of a legal proceeding is where an eDiscovery provider can be particularly useful.
Yeah, fantastic. We've been kind of skirting around the tech question, but I want to kind of ask it squarely. And Kiri, again, putting this question first to you. We're going to, in episode 4, really be pulling apart all of the tech stuff. So the detail in a way will come later. But I just wanted to ask you this question up front in this introductory video. Obviously, there's a big role for tech to play here, but how do you choose, or how do you decide between, say, a point tool, if you like, a single focused solution, versus a platform which has obviously got multi-functionality? And I'll probably ask this of you as well, Nat. So firstly, from the in-house lawyer perspective, how do you make a choice? What do you look at? What are the determining factors, in a way, at the high level, as opposed to the detail? Yeah.
At the high level, and it probably varies a bit depending on your organisation and what tools it has internally. So, Arup's an engineering firm, and it had a lot of IT skills. It had a lot of platforms that were available to it. So at times, we had tools and solutions that we could deploy internally. But when it came to really needing a sophisticated tool that solved the lawyers' problems as well as our business problems, you had to work out what the products were in market. And it's interesting, you watch it over time, and the historical context is the companies that produce these tools go through their own cycles, and they develop their own tools at different rates. So what was good for a matter 5 years ago might not be, even if you had the same matter coming up today, you might choose a different tool, because the tools don't develop and grow in the same way. And you've also got to make a really subtle distinction between what your matter really needs versus what the tool can provide. So there are some Rolls-Royce tools that have the most amazing analytics in them, but you really don't need it. Mm-hmm. So you could go to the secondary tool. The other thing that I think, if you're not close enough to the tools and paying enough attention and getting the right input in, you won't know the subtle elements of the tools that drive costs later on. Mm-hmm. So there are some tools that, it's actually really complex to get your head around, but you're trying to translate costs of volume of material versus costs of processing the information. And depending on your matter and how long it's going to go, the savings play out in different ways and the costs are hidden in different ways. Yeah. So making those decisions is it's a really fine balancing decision. But you're also looking at what the skills of the team are. So if you're working with a law firm who are very skilled in a particular product, and they're geared to that product, there doesn't necessarily make a lot of sense to switching them to another tool. So again, it's everybody around the table on that mutual tool going, what is the problem and what's the solution? But what is really good these days, and this is the point Kate was making, is that the tools are moving into these SaaS platforms, and they're becoming more available more broadly and at much more accessible price points. So there's a lot more flexibility about using the tools. I probably would add one other point around this, which is, as I've been taking teams and getting them used to tools, I probably can only get a team to take on one new tool at a time. So if you're looking at a solution that says, I'm going to use product A for this solution and product B for this, I personally might be reluctant to go, hey team, we're going to learn 2 brand new tools that are in 2 different places all at the same time, because that's actually cognitively a hard thing to get a team to learn. So it's where that team is at and what they need to solve their problems.
Can I just add to that too, Terry, that the litigation database tools, they are really quite complex. So you do need to spend quite a bit of time understanding exactly how they work, and work with a good consultant to show you the tips and tricks along the way. So they're not something you can just plug and play. You really do need to spend some time and understand exactly what the functionality can do.
So what I'm hearing from the two of you is that there's time needs to be spent in thinking about how you want to use them before you kind of go out and buy. But there's also going to be a training element that's obviously a pretty critical part of this as well. I want to ask the same question of you, Nat and Nick. Nat, is that your experience in a law firm? Very similar, different?
Look, it is, except I'll confess that while law firms are getting better at managing this kind of technology and working with it, we are, or at least I, am by no means an expert in this area. And often it's the case that I know the complexities of my particular case, but I don't know what I need.
Yeah.
And that's where I call on my eDiscovery provider to say, here is my problem, which platform is the right solution for us? And they are at the cutting edge of that business, and so I really trust them and have confidence in them to tell me and my client, this is the product that is going to give you the breadth of functionality that you require for your type of matter.
Nick, I guess in a way, being a barrister, you get to see the inside or the end result of a lot of these tools from a lot of different people. Any thoughts or comments to add here?
No, not really. I mean, it's, by the time it comes to us, it's been refined to the point generally where it's pretty shiny and lovely. I mean, the only thing that the things that are important from my perspective are that the documents are OCR to the extent that that's possible, that host and attachments are clearly identified, so you know what's with what. Natives be available, because sometimes the native file and the properties are critical, and that the database is searchable in a user-friendly way, so that if in the court or arbitration environment something's raised and you need someone to find you something, it can be found reasonably quickly.
Yeah, absolutely.
By reasonably, I mean immediately.
And a great point there, Nick, because I suppose that what you're seeing in the courts is how that's just reshaping the way that a trial is being conducted, or in an arbitration or a mediation, that immediacy. And if you're on, for example, the opposing side and you don't have that capability, I'm sure that that's kind of impacting a whole bunch of different things.
Yes, I think that's right. There's, I mean, generally the parties are, at least in the matters that I get involved in, on an equal footing in terms of sophistication and access to databases. But I've heard anecdotally that there's a perception difference when you've got one party who can do things quickly and efficiently electronically, and you've got another team that takes 5 minutes to find a document because people are rifling through folders. It may not ultimately affect the outcome, but there is that perception.
Kiri, I want to come back to you again on this question of data. And we touched on, but just wanted to kind of squarely address this whole concept of a document management strategy. Tell us a bit about what that is and in a way why it's so important in terms of eDiscovery.
Yeah, I think this is the magic sauce that if in-house counsel get it right, they actually are driving over time improvements for their business, for their lawyers, for their eDiscovery providers. And I think this is where I'd shifted the maturity of Arup at the time. When I was first doing matters, it was like everybody else. You just go in and you go, well, what's our document retention system and where are my records? But where you get to after using really skilled people at a time is this symbiosis of relationships where you're using external IT eDiscovery consultants who actually really know their business. They know how your infrastructure, your IT infrastructure works, and their ability to extract information out of your organization becomes really fast and efficient. Plus, they've ended up, by having to do it multiple times, you've ended up influencing your own business, your own IT team, and they start modifying their IT infrastructure for that that extraction process. Because I think it's really easy to think of document retention as I'm just going to go put my records in a box over there and not think about them. But we only put them in the box in order to get them out. And we don't often think about document retention from the, I've got to get them out and what will make getting them out better, faster, cheaper. So there's a real relationship that can emerge over time. And then that becomes a relationship that your lawyers can benefit from because they've got to get on top of an issue quickly. And suddenly you as an organization can just respond and you can bring a ready-made solution that makes them faster and more effective, that they themselves don't have to you're bringing to the table the learnings from your last 5-10 matters about what our organization's records are and how it works. So there's real efficiencies, there's a real symbiosis that you can drive that I think drives some really good impacts across your litigation and your broader litigation strategies.
And can I also add to that too, Kiri? Sometimes with large organisations, they're actually quite siloed in their own cells. So someone might be in charge of emails, someone might be in charge of the project database, someone might be in charge of the network drives. So there's no one person that sits across all of those sources. So certainly if you get engaged with an external eDiscovery provider, they can come in and sit over the top of that and go, okay, well, I need to talk to Bill for this and Sam for this and Jack for this. And I know how all of those systems work together, so I can go in, quickly find what I need and get it out as efficiently as possible. So it is really important that there is somebody that sits over the top and is across all of those different sources if you're regularly dealing with litigation or defending litigation.
Are you seeing that change a little bit now, just in terms of, I guess, a focus from record management to more information governance in organisations and law firms, because that's just become multifaceted and increasingly complex as well, isn't it? Are you seeing, are you seeing, Kate, and I guess a question for all of you really, the appointment of those chief information officers, or they have various different titles, but it's not the IT person, it's the person focused on information and data. Are you seeing that kind of happen as well?
Yeah, I think there's certainly a lot more. There's a guy at the top of the IT team now, and he's responsible to make sure everything is up and running, and he has his direct reports that make sure everything ticks over every day. We don't typically get involved with those people, but we would get involved with the more hands-on, into the nitty-gritty of the actual piece of technology that we're looking at. Same with the law firms. When we deal with the law firms, if we have to extract client data from the law firm, then we deal with typically not one of the lawyers, it'll be one of the IT team. Sometimes it's the lawyers if they've the client's given them the documents in a manner that we can quickly and efficiently collect. But yeah, we are seeing a lot of those extra roles come into play now, which is good. One thing we do see a lot of is the IT guys get really nervous that someone's going to put them up on the stand, and that sometimes can alter how they present to you and the questions that they'll answer. So getting them comfortable on that point is certainly something that we try to do very quickly in our conversations with them.
Yeah, absolutely. That discussion kind of leads pretty neatly into I guess the pros and cons of doing it yourself versus engaging an external provider. And from what I could do in researching for this session, in terms of having a look at the conversations about this, it seems to kind of go in waves. We're in favour of one, then we pull back in favour of another, and but it's turns and roundabouts in terms of all of this. So let me ask this question first of you, Nat. Is it kind of about keeping it all in-house, sending it all to an external provider, a combination of the two, or I guess something different altogether?
Look, obviously every law firm has its own approach to how it resources this kind of function. I work for a law firm that outsources this work entirely, pretty much, but there are firms that have their own eDiscovery in-house services. I think what's important is understanding what skills they have and what skills you have, and making sure that the necessary range of skills is covered, whether it's in-house or external. So, what I look for in an eDiscovery provider is someone who has knowledge of process. I have knowledge of the content of what my case is about and what I'm looking for and what's hopefully in the database, and that I look to the discovery provider to give me the knowledge of the process that we need to follow to extract that information. So I know what the right documents are. I'm looking to them to tell me how to find them. And in doing that, I'm looking for someone who's available, ideally who has legal training and understands the litigation process and why this matters and how it matters. I'm looking for someone who's cost competitive, and I'm looking for a service that will give me a one-on-one relationship. I use discovery providers where I know I have a dedicated person who I can call and who essentially, if not physically, at least remotely sits in our team and is someone that I can pick up the phone and ring in the same way that I would any other member of the team on this litigation. So whether they are within the law firm or within an external provider, from my perspective, doesn't really matter. What matters is that they've got those skills and that they have that level of responsiveness that I need during a fairly intensive part of the litigation process.
Intensive and stressful, I'm sure, Nat.
Yeah.
Right?
Can be.
Kiri, what are your thoughts looking at that from the in-house point of view?
The thought that emerged out of that conversation was that I think we're moving past the presumption that if you've got a large matter and a large number of documents, only large firms who have that internal capability have the skills to do this. I think what we really now have with the SaaS-based platforms are models of building the solution with any lawyer of your choice. And I think that was a really, really powerful thing, where you don't have to feel beholden to a small group of law firms who are doing it internally, and who have the database and the skills internally, because I think there's more ways of skinning the cat these days. So as a buyer of the solution and of the products, it gave me a lot more flexibility, because you're not trapped into one particular solution. I know that I knew that I could take any matter to any law firm, irrespective of what their skill set, and I could build a team around them these days to solve the problem. And that to me was powerful for me, because it means I had choice as an in-house lawyer about which lawyer I could choose the best lawyer for my matter, as opposed to, I can only choose lawyers who also have a very big in-house team. The other thing I always think about is, what are the organisational dynamics of in-house teams? And so this is for the very, very large law firms, their in-house eDiscovery teams might be offshore. They might be, they end up being a little bit secondary to the lawyers inside the practice, and that impacts their team and their skill sets and their recruiting policies. So I don't have at any one point in time, any team has a certain strength. So one of the judgment calls you've got to make, and this is whether or not it's an external eDiscovery or it's being done inside a law firm, is where is that team at? What are their skills right now? Are they at the top of their game? Because that's part of the question as well.
Yeah. And so the services ultimately that you might need from an external provider would reflect that, both in terms of time and skill set, right? Yeah. Kate, I'm sure that you have a really interesting perspective on this as well, obviously from, being a provider. So what are your thoughts on this?
Look, I've worked at some of the top tier law firms and been within their eDiscovery groups, and now obviously having Elms and running that as an external provider. I've also worked at other external providers as well. And I think I'm a bit like Kiri in that, if you're going to go to a top tier law firm, then it would make logical sense to use their eDiscovery team, because you wouldn't really want to separate that relationship. But if you're at a mid-tier firm or, a smaller firm, and you simply don't want to run the expense of having an eDiscovery team in-house, and, we are an expensive group, there's no doubt about it. We come with lots of technology and lots of really skilled people. So it is an expensive thing to bring in-house. Then I think certainly using it when you need it, just like a SaaS environment, you use us when you need us, we're on demand. So when you need us, we're there and we help you. When you don't need us, we go away and you don't have to pay any money for us. So I think, it depends on where you're at. I do like the idea of Kiri is able to use any lawyer she wants in any law firm, and she can just plug in the eDiscovery services as she needs them. And that's the same with what we have. Quite a few in-house counsel clients, and they bring us to all of their lawyers. They even sometimes bring us to their top tier firms to use on their particular matters. So once you get into a good relationship with an eDiscovery provider and they are giving you the client service that you need and they have the skills that are required, I wouldn't really see a need for you to change that relationship and unless something changed within that organisation. So I think it is a lot about building a relationship with your provider and making sure that you know where your job is and they know where their job is, so that you can all work effectively for the end client.
I think, as Nat was saying, that you're really all part of the same team. You're just located in different places, right? But that's really the approach that you take.
Yeah. Yep. And as I think certainly with COVID as well, we always thought when we first started Elms that we would have to have an office in every location, but now that COVID has hit, everybody's ringing everyone's on Zoom anyway.
Sure.
So it doesn't really matter what location you're in.
I wanted to just pick up on a term, because we've said it a few times, and for the folks listening, I'm not sure whether or not they would know what it means, but we've referred to SaaS and a SaaS environment. Would anyone like to have a stab at explaining that?
Well, I can.
Okay, go for it.
So SaaS stands for Software as a Service. And what that effectively means is that you don't need to carry any of the infrastructure or the people that run it or the security requirements around it. You can outsource that to another organisation. And at Elms, we typically outsource that to a company called Nuix, who are very experienced in data security and management. And we use their systems a lot, as do lots of law firms and government departments and police in Australia, use their systems in order to effectively help you manage your electronic document set. What the SaaS environment does is it reduces the cost of bringing that infrastructure in place. So it makes it affordable for everybody to use, not just the large law firms.
Yeah,
thank you.
So the classic example, Kate, was about 10 years ago. I was looking at the cost of buying a server, hosting it in a server farm, and buying the software and loading it up onto that server, and then having all the data imported into that hard server that was, effectively on corporate premises. And what the shift that happened at the time, because I was comparing the two, was I don't have to buy any of those things. It will just be hosted in the cloud. The software is available from the provider for a license fee, and all the data goes into that cloud-based, secure cloud-based place, and I've got a license to use the software associated with it. And once you were able to move into that SaaS platform, it's really driven up accessibility to the tools, and it's driving costs down. So it's been a really big shift that's happened in the last about 10 years.
Yeah.
Thanks for that. Thanks for doing that explanation as well. Really appreciate that. I want to wrap up by asking this question. We've been talking about the sorts of tools that we're using, the complexity of this, who we can use as well. And Nick, I wanted to ask this question of you. Do you think the ability to undertake eDiscovery today is a nice to have, or are we almost at the point of being around a breach of ethical obligations as lawyers if we're unable to undertake eDiscovery, or is it something else? Am I making that larger than it is?
I don't think it'll, certainly not at the moment, a breach of ethical obligations, and I don't think it's even heading that way. But where we are heading towards is an environment where most courts at every level, including tribunals, whether they're private or public, have an expectation of the litigation being undertaken electronically. I understand that QCAT is about to, if it has not already started, rolling out a program that's electronic based for it, and that rollout's going all the way up the judicial tree. So you still have the option, but the time in which you don't need to have a skill set is running out. I don't know if it'll be in my lifetime, but it's coming. It's here. It's not just coming, it's here. And it's not an early adopted thing. If you're in the profession for a while to come, you will have to understand how to use this stuff.
Nick, in the short term, is it possible that we might see it reflected in cost orders? In other words, you won't get them if you haven't been as effective and efficient as you could have been with the use of a reasonably priced tech.
I don't get involved in the difference, as in I don't have relevant or recent experience in relation to different costs associated with photocopying versus the e-platforms. If it's disproportionate in the sense that the e-platforms are 10 to the cost of doing things by paper, I can see an argument about that, but I don't actually know.
Yeah, thank you for that. Nat, what are your thoughts on that? Is it just a nice to have, or is it really risen to a different level now?
Look, it has risen to a different level. I think the Supreme Court of Victoria, I'm in Victoria, the Supreme Court of Victoria has, the commercial court at least, has an expectation that parties will conduct their discovery by electronic means. And even if that wasn't an expectation of the court, it would certainly be an expectation of your opponent. And it's a reasonable expectation when you're dealing with large levels of documents. So, and also I think increasingly the expectation of clients as well. So it really is something that all parties to a litigation are having to come to terms with, and it's becoming the standard rather than the exception now.
Yeah. Kiri, thoughts on that from an in-house perspective?
The phrase I've got in my head is it's a basic hygiene quality or characteristic that a legal team needs to have. The partner who says, "Oh, I've got a young lawyer who's really good with IT," doesn't cut it with me anymore. I expect you to be a mature team who uses technology well and who respects the skills that sit with that. And if you don't, I just know that you're going to cost me money and take me time. So if you haven't got it, I think you'll find the clients will look for people who do have that basic hygiene skill set now.
And presumably also not wanting, from an in-house point of view, paying for anyone to get upskilled in the technology in between, right? It's just kind of not on.
No.
Yeah, absolutely. Kate, any thoughts, closing thoughts from your perspective and what you see on that point? Nice to have or critical now?
Oh, look, I think it's critical now, and I actually think what we're seeing is that the in-house counsel clients are pushing it now. So they want to be involved. They want to know what things cost. They want to know how they can save money along the way, if they can save money along the way. So I think there is a big shift. But in saying that, I also think the law firms are thinking about it way earlier than they used to. And, it doesn't take you very long to get to a lot of documents. So with the volume of data that's being produced, the law firms certainly are taking it up more regularly than they would. We have some law firms that use it on every matter. And sometimes we go, well, we don't know if that we think that's too small, but that's their process. They use it, they follow it, and away they go. And, we develop different business models to help them work through that. But we're seeing a really big uptake being pushed primarily from their clients.
Yeah, it's almost like one of the things I'm taking away from all of you on that is that if this is something that you're doing and you're using, it's almost created a mindset shift as well, because you're thinking about things quite differently from the beginning all the way through to the end. Is that a fair comment as well?
Yeah, I think that's right. I think they're thinking about it way earlier than they ever did. Sometimes we get involved when the law firm's collected documents, and we would say that's probably too late. We like to get involved right up front when pleadings are closed and they have to think about what documents they need to collect and from what sources. So we like to get involved very early on so that we can identify any of those risks with documents that, you know, when you spoil the metadata, that's going to cost you a lot of money down the end. If you know your documents exist in two places, so if they exist in a project database and a network drive and you've copied them from one to the other, then you'd want to collect the one first that has the good dates on it, so the second set deduplicates out of the database. So there's lots of places to get involved on. I think law firms are certainly looking at things a lot earlier than what they would have 10 years ago.
You're actually compelled to, because of the practice directions here that require document management plans to be in place, and they're things that the parties are required to collaborate about right at the beginning of the dispute.
Yeah. So it's kind of squarely in the box of must have, not nice to have, by the sounds of it from all of you, right? So I it's just a fascinating discussion to me as someone who's not involved in the eDiscovery world, but there's a lot of complexities and just a lot of moving parts. So I am really going to encourage the folks that are on this session, which, as I say, is really an overview and an introduction to all of this, to dive into the other 4 episodes as we kind of pull all of those bits and pieces apart and be able to consume it, I guess, in a way, in bite-sized pieces that you'll hopefully find useful and very practical to take back to your own firms and organisations. Huge thanks to you, Kate, again, and to Elms for collaborating with us on this series, and of course to Nat and Nick and Kiri as well. Really, really enjoyed the conversation today. I know that folks can reach out to each of you individually on LinkedIn if you would like to, or they can connect with you also, I'm sure, in lots of different other means. From the Centre's point of view and from Elm's point of view, you'll certainly find us on LinkedIn, Facebook and Twitter as well. So do feel free to reach out. Just a reminder again that episode number 2, which is all about the process, is in fact coming up reasonably soon on the 9th of March. So we would love to see you there at pretty much the same time, 1 to 2 p.m. Australian Eastern Daylight Time as well. So again, thank you everyone for attending. Thank you everyone and all of the presenters for your time. Really appreciate it. And we'll see you for episode number 2. Thanks a lot, folks.
Bye.
Bye, everyone. Thank you.